In December, the Wisconsin Supreme Court is going to hear oral arguments in Miller versus Carroll. Miller versus Carroll is a Court of Appeals decision that deals with a very modern, new, up-to-date issue on use of social media, and especially how it involves judges. And it's a case where I'm a little surprised the Supreme Court took review, because I thought the Court of Appeals decision got it right, and I thought was well reasoned, and really, really good decision. And that's why I'm a little surprised the Supreme Court took the case, and a little worried about where they may go with it. The facts of the case involve a custody trial in which one of the allegations by the wife was domestic violence by the husband. After the hearing, the evidentiary hearing, but before the written decision came down, the judge accepted the mother, whose name was Angela, as a friend on his Facebook account. He, or she rather, liked several of the judge's posts, and she posted on her site some information about domestic violence, although it's not clear if the judge actually saw it or not. Eventually, several weeks later, the judge came down with a written decision ruling entirely in Angela's favor. And sometime after that, as I recall, 3 weeks afterwards, Timothy finds out through the guardian ad litem that subsequent to the trial, but before the decision, that Angela and the judge became friends on Facebook. Timothy then goes back to court and asks that the decision be vacated and the case be sent to a new judge on the grounds of judicial bias and ex parte communication. It goes for decision to the same judge who heard the trial, who wasn't about to criticize himself. And what he said was, I had my mind made up after the evidence. It took me a couple weeks or whatever it was to write down the decision, but being a friend with Angela, her liking my posts, anything she posted, didn't influence me if I saw it whatsoever. So I already had my mind made up, and it was just a matter of taking my thoughts and putting it into paper in terms of the written order. Timothy appealed, and the Court of Appeals came down with what I thought was a very, very reasonable decision. What they said essentially is that the use of electronic social media, ESM, is something that courts need to take into account and need to think about, and that in this case, the actions by the judge had the appearance of impropriety. Essentially, they didn't come out and say that the judge violated any ethical standards, but they did say that accepting her as a friend, which requires an affirmative act. If you're not on Facebook, then I know a little bit about it. Someone asks to be a friend, and you have to affirmatively accept that person as a friend. That by doing that, whether or not the judge knew that she liked his posts or read anything that she posted, had the appearance of impropriety, had the appearance of ex parte contact, because the husband, rather the father, Timothy, knew nothing about this. The court was careful to say it was not making a bright line rule here. It's not making a per se rule. It's not saying that judges cannot be on Facebook. It's not even saying judges can't have friends who might be litigants in front of them. It didn't go that far. It just said, looking at the particular facts of this case, we find the judge's conduct was inappropriate, and they reversed and remanded for a new trial in front of a new judge. And again, as I said before, I'm a little worried that the Supreme Court accepted review on the case because I thought that was a reasonable decision under the circumstances. Doesn't appear the judge did anything overtly or directly unethical, but these custody and placement issues are highly emotional, as all of us family lawyers know. People invest their hearts and soul into it, and it's important that the litigant has the feeling and the belief that even if they lose, that they had a fair hearing in front of a fair and impartial magistrate. I have had in my career at least 2 and maybe 3 instances where I lost a hearing or a motion or a trial. Well, I've lost more than two or three, but so follow the sentence through. Two or three in my career where afterwards I've asked my client, do you want to take an appeal, or if it was from the FCC, a de novo? And my client has said, you know, Greg, this one case commissioner, another case judge, gave so much thought, consideration, and care that if we can't convince him or her, depending on the case, we're not going to be able to convince anyone else. Essentially, what the client was saying is that they were impressed that even though the result wasn't favorable, that the process was fair and impartial. And when you're dealing with how often you're going to see your kids and what's going to happen with your kids, that is an incredibly important belief that people should have in how our system operates. We're very fortunate in Wisconsin that our system is an honest system. I have never heard in whatever years I've been practicing, a lot more than I want to admit, I've never even heard of an allegation of a judge being bought or bribed or anything like that. Used to, years ago, have allegations of ex parte contact. You don't even hear that anymore. Judges, in my experience, uniformly want to do the right thing, and they want to do it within the bounds of judicial discretion and judicial ethics. ESM, though, presents interesting issues and problems in this, because you can't say judges should never be on Facebook at all, because we live in a political climate. Judges have to run for re-election every 6 years. They were recently appointed, sometimes the next year, and ESM is critically important in the political process. Judges create websites, they raise money for it, they campaign on it, and their websites may not even be run by themselves, may be run by third parties who they hire, because these campaigns, especially in Milwaukee and Waukesha counties, can get quite expensive to run, and you may have to hire a professional because there are a lot of people to deal with, and you only have so much time, especially if you're a sitting and serving judge at the time. In addition, there's types of ESM other than Facebook. We have, of course, LinkedIn and Pinterest and God knows what else is out there. I'm at the age where I'm not totally familiar with all of them, although I am on Facebook, I am on LinkedIn, and I'm familiar with those at least. And there are a number of others, and they prevent various levels and various questions that can come into play in individual circumstances. But that's why I was hopeful that the Supreme Court would reject review. I thought the Court of Appeals did a good job of saying, hey, we're talking about just this individual case. Be careful of how you apply it. There's no per se rule. And I'm not sure where the Supreme Court is going to go with it. I suspect part of the reason they accepted review is that it's a, quote, sexy, end quote, issue. It's one that may get some publicity, and Supreme Court judges run for election as well, and they may be attracted towards that. But I'm a little worried about a blanket rule based upon the facts of this case, which are somewhat unusual. What's unusual is the combination that it was a custody battle, that the judge accepted not the lawyer as a friend, but the litigant, that the timing of it, and this is what's especially interesting, was between the evidentiary ruling and the final decision, and that the Angela, the mother, both liked the judge's posts and posted information on her own site that may to some extent be relevant, in her opinion, at least to her case. I don't think those facts arise a whole lot, and therefore it worries me in terms of the Supreme Court intends to create a blanket rule. This might be a really good time for the Supreme Court to say, you know what, Court of Appeals, you did a nice job, you analyzed this well, you discussed the issues well, you came to a reasoned decision, and we're going to just let this stand. But we're not going to let this go because it arises issues that need to be studied. And this might be the type of thing that rather than utilize one fact situation to make a blanket rule for some form of a commission, committee, whatever the Supreme Court appoints, to discuss and consider the various types of ESM, the various issues that might arise, and maybe make some recommendations for rules that judges should have to follow. I would imagine judges would welcome that because, as I said, they run for re-election and they need to have some ESM. You can't say judges can't, because if the judge's challenger is a non-judge, you're going to have a mismatch in terms of publicity and campaigning during the election. Now, if you have to say a judge can't be on ESM, you can't say that about the challenger, and that just wouldn't be a fair way of running an election. But again, that's an issue that I think should be considered in a broader context, and I'd like to see the Supreme Court appoint a committee, give it some thought, give it some study, and come down to a rule that might apply in all circumstances so that litigants have a degree of comfort that the decisions, good, bad, or indifferent, are at least made by a neutral magistrate who wasn't influenced on an ex parte basis in any way, or even have the ability to be impacted on an ex parte basis, and also that judges know the safe harbor of what they can do and where that line is drawn. Friendly reminder to subscribe to Wisconsin Family Law Case Finder. Subscription information is on screen for you. We have over 1,600 family law cases in Wisconsin, many cases from out of state, organized into 135 different family law subject areas. You can search by the word, search by the area, search by the case. It's an outstanding resource, and if you practice family law in Wisconsin, you ought to subscribe to it.